we're going to continue, and we have Attorney Tillotson for the town.
Thank you very much. Good evening, Madam Chair, members of the board, members of the public. My name again is Diane Tillotson. I'm here representing the town of Falmouth. And although I would be the first person to disagree that context in any hearing is important to some extent, after listening to Mr. Senni's hour-long presentation on how we got here, and I believe the question he asked at the beginning was how we got to where we are today, I would suggest to you all that a far more important question is whether or not there is a viable route to resolution of the issues that have been presented before you tonight through conditions on a special permit that will allow these turbines, which are incredibly important to the town, to continue to operate while addressing the very legitimate, and we acknowledge that they are very legitimate, impacts on the neighbors. That is not a question that I am going to address tonight. I will reserve the presentation at the special permit hearing, which is scheduled for October, to address that issue. But I would suggest that we need to be future focused. I'm going to address first, per the chair's direction, the issue of the appropriateness of the issuance of a cease and desist order with respect to Wind 1 at this time. And I would suggest to you, similar to your determination back in June and in the decision recently issued by you, where you denied the enforcement request that was made, it is similarly appropriate for you to deny this request to cease and desist. And I'd suggest that there are three factors initially that you have to look at. The first is whether or not the illegality that's complained of, and there's no question that a court, the appeals court, has determined that Wind 1 requires a special permit that it does not have. So technically, it is operating illegally at the moment. The question for you is whether that illegality can be remedied by appropriate zoning relief and whether that zoning relief has been applied for. And I would suggest to you that the answer to both of those questions is yes. In this case, Wind 1 can and should, I would urge, receive a special permit from you. You heard Mr. Senni's presentation, who's already suggesting to you, when the public hearing has not even opened yet on Wind 1, that you should deny the special permit because we can't possibly meet the criteria. Again, I'm not going to get into the substance and refute all of the slides that were put up on the board, but I would urge you to at least put them aside in your mind for purposes of considering tonight's request, because many of the excerpts from the various sound studies and acoustical studies that were presented up on the board tonight were quite selective, and secondly, were annotated with Mr. Senni's own comments, who is not an acoustical analyst and not a sound technician. So again, with all due respect to Mr. Senni, I would suggest that much of what was on that in that presentation was irrelevant, and that I would ask that the board at least defer your determination on the special permit until you've heard both sides' presentations, and that if the town obtains the special permit that we've applied for on Wind 1, that will fully remedy the zoning violation that's complained of, and I would urge you to find that, or to defer any action on any type of cease and desist request. I do not disagree with Mr. Watt that the citation to the Haddad case, in fact, most of the cases that deal with the appropriateness of deferring an ultimate remedy where there's a zoning violation are related to tear-down cases as opposed to, or demolition cases, as opposed to use cases. I think perhaps the reason for that is that a cease and desist order frequently will be appealed by the person against whom it's directed, and a court will make a determination as to whether or not a stay is or is not appropriate. You don't necessarily see those cases reported either in the appeals court or in the Supreme Judicial Court. The principles, however, in the Haddard case, in the Shepard case, in the Del Prat case, all of which I cited in the memo that I submitted back in June, are the same, which is whether or not the board should defer on an ultimate remedy until it has given the applicant the opportunity to apply for zoning relief if zoning relief is available. Again, in this case, zoning relief in Win 1 is available and the town has applied for it. And I would suggest that, I don't know the Travers, I guess. Tavares, thank you, case that's been cited tonight, but I did listen carefully to Mr. Watt's presentation of that case, and I would suggest that there's a very critical difference between the facts and the procedure in that case and the one that you have in front of you tonight. And that is, in Tavares, apparently the special permit was applied for and denied prior to the building inspector issuing an enforcement order. That's not the case here. This board has not yet ruled on the town's special permit application, and I would urge that at a minimum, that this board should await a determination on that special permit application prior to making any decision on the cease and desist application. The second consideration, which I think is similarly very important and plays in here, and I don't disagree that perhaps Mr. Gore overstated the importance of Judge Muse's determination, if in fact you read that to mean that any order by him would be illegal under that injunction. I don't think that's what Judge Muse meant either, but I do think what's critically important about Judge Muse's order in this case is that he did exactly what a board should do and what the court will do if they're asked to look at a cease and desist order and or a request for a stay for an operating enterprise. And I have actually sought cease and desist orders from the court and gotten them, and the orders that I get are similar to what Judge Muse issued in this case. I represent a sand and gravel company in Bourne, where the building inspector had issued essentially a shutdown order. The court issued a stay of that order subject to certain conditions. The same equitable factors that were employed by Judge Muse in weighing the harm that the neighbors were complaining about versus the harm to the town if they were ordered to completely cease operation of the turbine would be exactly the same factors that would be employed by a court in this situation, and I would suggest would be appropriate for you to look at. And again, as in any situation, what a court of equity will do is weigh the competing interests of the parties and attempt to fashion a temporary remedy. And again, the injunction that was issued by Judge Muse was issued before trial. It's a temporary remedy. It will be presumably revisited again after the trial on the merits takes place. In our case, the trial on the merits essentially will be the special permit hearing that will commence at the end of October before you. But I would suggest to you that in the interim, the order that was issued by Judge Muse is fair. There is no more nighttime operation of the turbines. Turbines don't operate on Sundays, and it has had at least some mitigating effect. The neighbors might not be completely happy, but interestingly, I haven't heard a lot of comparisons about noise experiences prior to the issuance of Judge Muse's order and afterwards. And at least the anecdotal information that I've gotten from Mr. Patamas is that the complaints have been far, far fewer since that turbine operation was curtailed. So I would suggest to you that in the interim, that is sufficient. It's an order that's in place, and that it is sufficient to protect the very real concerns of the neighbors. Third and finally, there is no suggestion, I don't think, that the town has operated in bad faith. I know that Mr. Senni may feel differently. He has spent an hour articulating why he felt the town should have done a number of things that were not done. The town looked to town council and to others, and in fact were upheld by the Superior Court in the first instance in making a determination that a special permit was not necessary. It was not a decision in bad faith. In retrospect, it may have been a mistake, but I would suggest to you that we all make mistakes, and not every mistake is made in bad faith, and that there is absolutely no evidence that the town proceeded in bad faith in this case. I would suggest that everyone in this room is at this point attempting to proceed in good faith and to apply the law as they see it. So I would respectfully suggest to you that based on all of those three factors, the good faith factor, the fact that this violation can and might well be remedied by the issuance of a special permit, and the fact that we have a preliminary injunction in place that provides some measure of mitigation relief to the neighbors and to the complainants in this case, all of which suggest that the cease and desist order that has been requested is inappropriate at this time. And I'm happy to answer any questions. Thank you.
Paul, any questions?
No. Well, just one. Forgive me, but who determined that a special permit was required? The land court, the appeals court?
The appeals court.
Okay.
The appeals court. And the appeals court determined that it was required, I believe, in May of this year. The building commissioner ordered the town to apply for the permit in June. The town did apply for the permit within the 30-day window that the building commissioner gave them, and we're awaiting the opening of the public hearing.
Ed?
That's all.
TJ? Ken?
So you brought up, I thought, a good point of talking about the harm, considering the harm to the neighbors versus the harm to the town, and I'm wondering if you have any more information you could give us about what the harm to the town would be of a cease and desist order until such time as the special permit was issued.
The harm to the town is economic in nature. I would need to find the specifics, but I know it's upwards, it's in the millions of dollars range, plus a forfeiture on financial obligations that the town has that it would be unable to meet in the event that a complete cessation of operation was ordered.
Right, but would a cease and desist order at this time necessarily be permanent? Or?
Well, it would not necessarily be permanent in the sense that presumably if a special permit were issued, presumably the cease and desist order would be lifted. However, given the schedule that we're looking at, and given the fact that we're not opening the special permit hearing until the end of October, and I think that, I don't want to get ahead of myself, but I think one of the things we'll likely discuss later on, perhaps not in the public hearing, is a scheduling of time for additional testimony by acoustic engineers and so forth. It is very likely that a delay of several months, if this board were, for example, to issue a cease and desist tonight, it would be likely that there could be a delay of as much as 3 to 6 months, and that would be a substantial financial impact on the town.
So that's what I'm trying to weigh, is what's that impact versus at least the alleged continued harm to the neighbors?
I'm not sure you've heard a lot about the alleged continued harm. What you've seen up on the screen are quotations that were given in the sworn testimony of these abutters. And presumably that sworn testimony was given at the preliminary injunction hearing before Judge Muse before he issued that injunction. He credited that testimony, and I don't disagree with Mr. Senni that that an injunction is not always easy to get. I think Judge Muse carefully crafted the injunction after listening to either the testimony or the affidavits. I don't know where these abutters would have given sworn testimony except in that Superior Court proceeding or before this board, but that would not have been recent. That would not have been after the injunction issued. It would have been prior to, and it would have been the basis upon which the injunction issued. I haven't heard any suggestion that there is any change. In fact, there's been very little testimony that's compared, and I'm sure we'll hear it during the special permit process. That'll be part of the hearing. There's been very little testimony that's compared the experience of the abutters prior to the issuance of the injunction and after. The one quotation you have is one that was at the very beginning of the presentation by, I cannot recall the name of the party, I'm sorry, but basically saying that Sundays were a break for her. I'm sure you remember the slide.
Yeah.
And, but aside from that, there has been very little suggestion that, I'm assuming that the neighbors continue to feel that the injunction issued wasn't sufficient or we wouldn't be here. But again, I don't know that when I look at the presentation, my view is that anything short of a complete cessation of operation is going to be not satisfactory to them. But I haven't seen much to support that at this point. And again, I think that Judge Muse did a very good job of trying to balance those harms.
Well, Judge Muse was addressing the nuisance determination, yes?
That's correct, but
So we have a different situation now because we have a decision of the court that there should have been a special permit and they're now operating without one, which you acknowledge.
that's correct. That's correct. And that's true. But again, I go back, and I think they're all, the cases are obviously related, but there are certainly many case decisions, most of which deal with tear-down orders, but the principle, the equitable principle is the same. Before this board would issue a final remedy, you give the applicant an opportunity to apply for the relief that could fix it.
There is, though, a fundamental difference, wouldn't you agree? If a tear-down order is implemented, that's an irrevocable solution, whereas that wouldn't be the case necessarily for a temporary stoppage.
That's correct, but again, the case of a temporary stoppage brings up the question of, what is temporary? And there is already a temporary stoppage on Sundays. The town has managed to change its projections and and budget in order to meet the curtailment that's been ordered by the court to date. I'm not certain that, and I haven't done an analysis, what would happen if we were stopped operation for 2 months, 3 months, 4 months. I haven't done that analysis. I'm not sure the town has done that analysis. But I do know that it would be a substantial impact on the financial operations of the town.
And my last question, so Wind 1 has been in operation without the required special permit for how many years?
I believe it was up in 2010, sometime in 2010, so approximately 5 years. Is that correct?
Okay.
May of 2010, perhaps?
I think it's March.
March.
All right, thanks.
Does anybody else have any questions, John? Okay, I don't have any questions either. So we can take public comment. And please touch on things that haven't already been addressed. I know a lot of people are represented by council. Yeah, I'm just going to continue my thought.
Is this Win 1 or is also?
Let's limit it to Win 1 because we will have an opportunity to discuss Win 2, if not tonight, possibly at the next hearing. So, again, I guess I just want to limit to what hasn't been, new matters is usually what we try to limit comment to. So if you could just provide your name.
Okay, I'm Barry Funfar, 27 Ridgeview Drive, and the 10 times rotor diameter that was mentioned is about 2,500 feet. My home is between 1,500 and 1,600 feet from both Wind 1 and Wind 2. First, I want to comment on some comments made by the town's attorney, Diane, is it Tillotson?
Tillotson, yes.
Okay. Future focus, it's like, I didn't like that. It's like I've already lost over 5 years of my life to these turbines. And there's no need to be an acoustical engineer to know when I'm affected by Falmouth's wind turbines. The DEP measured wind turbine noise as high as 11.7 dBA on my property. Of course, they then average it out and, oh, it's below 10. I don't hear an averages, I hear the peaks. If a dog is barking 24 hours a day, and we call the dog officer or the police, and they get it to quiet down to only 12 hours a day, I'm still not going to be happy. And I'm one who, I used to garden, that was my life on my property, and these things have driven me out of my yard. I haven't gone out there for 5 years now. It's a jungle. Far, far fewer complaints. We have given up on trying to communicate with the town. I submitted to the so-called expert panel on health, the Massachusetts panel developed by the DEP and the DOH. I submitted 512 pages of all my complaints. If I were to just give you all the complaints and all the letters that I have sent to town and state officials, you'd be reading for a long time. If a cease and desist order were issued, the town might hurry up and we wouldn't be doing this for another 5 years. And every quote Chris Senni made of me, Barry Funfar, I would stand behind now. And most of that was, it doesn't matter if it's operating at night, the daytime is what kills me. So cutting it down to 12 hours, only 7 in the morning to 7 at night, that doesn't help me a tiny bit. I have attended countless meetings of every board in Falmouth that has had anything to do with these turbines. I've also attended every seminar and conference on wind turbines that I could find since mid-2010. Never have I seen a single Falmouth public official in attendance at any of these informational programs. I wonder they have garnered their facts that they should need to make some informed decisions. Attempting to use the public process of town meeting, I didn't just jump into a court wanting to be, I didn't want to sue. 3 times I presented articles at town meeting, 3 separate town meetings, and to stop the turbines, and they actually passed one, and then to no avail. I guess there was no money to back it. Meanwhile, we wind turbine victims continue to suffer the avoidance of our homes and properties because of noise, shadow flicker, and vibroacoustic effects. There are also psychological factors that enter into this traumatizing equation, being called NIMBYs and worse, when we are the ones who have suffered and learned firsthand the negative consequences of living too close to these machines only adds to our stress levels. At a prior meeting of this very board, I think it was towards the end of July, to hear this board state that the town has always acted in good faith, and I heard what you had to say to our attorney, Mr. Senni. I didn't leave that meeting thinking that that explanation fit the bill there. To me and my wife, we left that meeting extremely hurt because we think you're far, far off the track thinking the town has acted in good faith, and for a lot of reasons. We won our nuisance determination from Falmouth ZBA. The town was ordered to mitigate the nuisance. How many years should this take? It's going to Ken Foreman's question earlier. It's like we're in our retirement years. How many years do we have left? And we'd like to use our home any and every day when we feel like it. We're driven out. And my last comment is justice delayed is justice denied. Thank you.
Thank you. Let me see, Amy, have any questions? Okay. Yep, whoever would like to go.
We're neighbors, and I just wanted
Your
to...
name.
Could you give your name and,
It's Kathy Mount, and we live on 221 Blacksmith Shop Road.
okay.
And I just want to make it very clear that we are very adversely impacted by the wind turbines. It's a noise issue that's constant most of the days. Many times we just want to leave our house. We go away frequently, just overnight or for a few days to get away from it. To give you an example, we said to friends, come over anytime you want. We didn't know they came over when we weren't home, and they stood on our porch, and they said they waited till the airplanes went over so they could listen to the wind turbines. And they kept waiting, and they found out that the airplanes didn't go over, it was the wind turbines they were hearing. And that's sometimes the kind of noise it can be. We can't keep our windows open when we have the great spring weather or the fall weather, because the noise is even worse in the house with the windows open, so we have to shut our windows down. I used to love to work in the garden. I don't work in the garden anymore. These are things that are very upsetting to us. And I ask you to think about the fact that they've been going for 5.5 years as compared to the maybe 3 to 6 months more that this is going to take to resolve. That's a big difference for us. Sure, 3 to 6 months seems it's a long time for the town, but we've been putting up with it for 5.5 years.
Oh, if you could just provide them to the clerk, he'll stamp them in and he'll disperse to us.
Okay.
Thank you. Yep, sir in the red.
Dr. Henry Dick. I'm a former town meeting member.
and I was there when we enthusiastically and overwhelmingly voted for these windmills. We thought it was great. We were not well informed. When the 2 new windmills were proposed, we were never told that no sound studies had been made. It was not discussed why they weren't being put up in the town when they were originally being put up. It turns out they weren't being put up because people had done some investigation and discovered what a bad idea it was. So then they got put up, rushed down to Woodward's Hole, where I raised my hand with everybody else and voted in favor of them. And then I discovered what we'd done. And so I am speaking tonight in the apologies for my negligence as a town meeting member in having voted for this, having been poorly informed by the town of the potential consequences, and the fact that they had not done due diligence, which is clearly evident for the presentation tonight. And for the first individual here who just spoke ended with justice delayed is justice denied. And the truth of the matter is you can't look at Mr. Funfar and not realize that he has been shattered by this experience or any of the others. And I think that enough is enough. There's a basic principle here that's much bigger than what we're dealing with this one set of windmills. We're settling about what happens when people decide that the state is more important than the individual. And our country was designed on the principle, and with lots of checks and balances, that we would prevent the majority from infringing on the minority. And if you do not give a cease and desist order tonight, it sets an unbelievably bad precedent in this town and what this town is about. The most important thing in this town is the health and welfare of the citizens, and the most important thing in this town is how we deal with when we're wrong. And we have been wrong. I voted for them. I was wrong. I was negligent. It's time that a firm foot is put down. Put that down tonight. Thank you.
I just have a question. Sir,
Oh, I'm sorry.
Mr. Deputy. I just have a question about just your address. You don't provide it.
Oh, 392 Boxbury Hill Road.
Okay,
I
thank
am
you.
not affected by the windmills in any way.
Okay, thank you. Yep, ma'am.
I'm just going to give you a statement I made at the Board of Health in 2012.
Diane, can you give us your name and address, please?
Sure, I'm sorry. Diane Funfar, 27 Ridgeview Drive. That statement I gave to the Board of Health in 2012, pouring out our hearts on what was bothering us. The reason we are asking for the cease and desist is whether the town gets a permit or not, that's not going to help those of us that are affected health-wise. Health matters, and there's no getting used to this wind turbine. We leave our homes on a daily basis, and we try to leave the town as often as we can. And it's not good. It's torn our family and our whole family upside down. I'm just going to read the range of symptoms that we've experienced. Anxiety, eye problems, stress, depression, irritability, anger, palpitations, panic attacks, high blood pressure, migraine, sleep deprivation, tiredness, exasperation of PTSD, and even suicidal tendencies. We are suffering and need relief. Please help us return to enjoy the peace and tranquility we once had in our own home. Please turn these torturous machines off. Thank you.
Thank you. Yep, ma'am.
My name is Sharon Eddy, and I'm 125 Blacksmith Shop Road. I'm guessing about maybe 1650 to 1750 feet from Wind 1. The town acted in good faith. That upset me, because when I got a letter about this meeting tonight on butter, 4 or 5 of my neighbors never received notices in our mailboxes from the town notifying us that there were going to be town meetings regarding these turbines. Brian Hunt was one. He didn't get anything. Hamlin's didn't get anything. I didn't. So I'm, bad faith right there. And just last week when we had high winds, I think it may have been 7 in the morning, 8, I can't remember, all the dogs went off crazy from the noise from the turbines. So it affects still, you know. You can do what you want, but it's still going to affect people who are living in the neighborhood. That's all I have to say. Thanks.
I would just like to address, and maybe Sari would like to address the notice.
The notice is sent by this board, the staff of the Zoning Board of Appeals, from a certified abutters list within 300 feet of the wind turbine property. And I'll be more than happy to go through the file to see if your name was actually on there. I know Mr. Hunt is not within 300 feet of 154 Blacksmith Shop Road.
Why would they choose 300 feet when they know?
Because that's what is required of this board to notify the people, but it is also published for 2 weeks in the Enterprise. And that's a Mass General Law statute, so.
Okay, well, I'm just saying.
So there was plenty of
But I
notice,
got a
plus,
notice to be at this meeting tonight,
Yeah.
so.
so it's 300 feet.
And I agree with somebody else who just reiterated, I'm going to reiterate. Turning them back on, getting the permit isn't going to help any of us. And we are a few, we're not the whole town, but we do have rights. Thank you.
Thank you. Would anyone else like to, I guess, the gentleman in the pink? Let's see, somebody's asked.
Malcolm Donald, 124 Ambleside Drive. It seems to me that we're talking, we have a pretty narrow issue tonight about it's whether enforcing a cease and desist order. In other cases, do we ask the negligent party, do we ask them how much of a financial impact it's going to be to them if we cease and desist them? I mean, this is crazy. We're talking about the law. We're talking about right and wrong. If the town has to follow the rules. It's not the different, you know, it's the same rules that we live by. So, I mean, it's irrelevant how much money the town's going to lose. Well, you know, okay. The second point I want to make is it's just really incredible to hear Diane Tillotson, the attorney for the town, say that the town has acted in good faith. I mean, it is just preposterous. And you've seen that. That was identified through these slides tonight. I mean, this is damning. This is disgusting that our town has operated this way. And furthermore, the town has ignored the neighbors. It has procrastinated on trying to remedy the situation, and it has attempted to outspend the neighbors. I mean, the town has deep pockets. It can spend all this money on attorneys, spend more money, cause the neighbors to spend more money, outspend them. That's the whole thing here. That's what we're looking at. And you call that good faith? I don't.
Can I just clarify, I'll just respond to one, and not, I think that you referred at the beginning, asked about financial impact. And I think the question was what the harm was for the town vis-a-vis the harm to the abutters. And that the town's response was monetary, financial. But I don't think that that was the question from the board. So I just wanted to clarify that.
I don't understand what you're asking.
We asked what the harm was for the town if the wind turbines get shut down, not what their financial impact was. The response was there would be a financial impact. But the question from this board was not what is the
Why is it relevant?
Well, the harms certainly are relevant to our inquiry of what the harm is to each side of the equation here as to whether the turbine should be shut off. in the interim pending the special permit application.
All right,
It's part
well,
of our inquiry.
yeah, and-
That's all, I just wanted to
okay.
clarify that.
And then the other thing is, Ms. Balan, you spent a number of minutes, 5 or 10 minutes, lecturing Attorney Senni about how we weren't going to talk about the special permit, and it doesn't have any. And then the attorney for the town, Diane Tillotson, gets up and talks about the special permit. Like that's the.
I'm not going to engage you in an argument.
Right.
But I believe Attorney Tillotson said, I'm not going to speak about the special permit.
Oh, but
today."
she did. She said the special
Okay.
permit will
right.
remedy the situation. And so that's why you don't need a cease and desist.
Thank you. Yep, sorry. And if we could speak to, I guess, something new and also
Cease and desist.
the cease and desist, because it is.
Right.
Yeah, thank you.
Day Mount, 221 Blacksmith Shop Road. I filed a complaint today. I file them, but the town never responds. They send me a little email saying they got it, but it's almost useless to file complaints. So most of us have given up. I just want to make the point, it's a new point. The town, this issue has been decided. It has been decided that the turbines are a major problem here in Falmouth. It was decided after weeks and weeks of study by the planning board, and they put a proposition up to the town meeting, and the town meeting voted unanimously, and there was not one selectman, not one, who opposed that. It passed unanimously. This town has decided that industrial turbines don't belong here. They don't belong anywhere. It was not restricted. It didn't say, it's okay for those ones up there on the hill. And my point is, it didn't say, well, it's all right to operate part-time, or it's all right, we're only protecting the rest of town for half the time. It said they are not appropriate, and the biggest turbine that's permitted is 6 times smaller than the turbines that the town have up there. And that's my point. This is not a purely legal proceeding. We are neighbors talking to neighbors. They're not court rules. Please take into consideration that you and everyone else in town is protected by this action of town meeting, and the selectmen agreed to it, and we, the minority, are not. That's why we ask for a cease and desist. We want to be the same as everybody else, until and unless a permit is issued. Until those turbines are turned off, everybody else is different, and we are class 2. Thank you.
Sir?
Hi everyone, my name's Dave Moriarty. I live at 93 Lowell Road. I'm a town meeting member. And I'd just like to say, there's nothing more important in this world than good health. If you don't have your health, you don't have anything. No amount of finances is going to fix bad health. And here we are intentionally hurting our neighbors, which is unconscionable to me. And we have a remedy here tonight. Tonight, we can stop torturing our friends and neighbors. We can do something about this here tonight. We've been waiting 5 years. The town has done nothing. It's had 2 years to do something. They've done nothing. If you order a cease and desist here tonight, I guarantee you that the court will do something, that it'll expedite what's going on here. We will come to a quicker remedy of this, and we'll get our town back. Our town has been completely divided. Neighbor against neighbor, East Falmouth against Woods Hole. I mean, this is just horrible. This is unacceptable. All I'm saying is, if you order a cease and desist here tonight, you'll be doing every citizen of Falmouth a great justice. Thank you very much.
Thank you. Yep, sir.
Thank you. My name is Neil Anderson from Blacksmith Shop Road. I really don't know what to say anymore. It's been over 5 years, and we're getting the heck beat out of us when we're home. It's not very healthy. Labor Day, it's a windy day. Some people go out sailing. We leave the house, we drive around just to stay away from the turbine. The following Tuesday, I was supposed to work all day. It was a windy day, and I just can't leave my wife. She stays at home. She works at home. I couldn't leave her at home, so we took off again for the day. You gotta look at the small picture, okay? You have an illegal structure. It doesn't have a special permit. I'm a home builder. I know how that works with additions. You don't have a special permit, you get a fluorescent sticker, stop work order. We have a structure that not only does not have a special permit, this thing is invading us. It's inside our house. You've seen the files there and the reports from the acoustics of this low frequency inside our house. And as my neighbor said, that's inside my house, that's inside his house. And you know what else? It's inside my head, it's in my chest cavity. It's extremely uncomfortable. It raises that flight or fight instinct into you. And we're pretty tired of fighting, but we're not going to give up, because this is our home. This is our house. Diane Tillotson mentioned something about future focused. You know, the permit. The permit's going to solve everything. Well, we've been trying to get a permit since 5 years ago, and we're still in the same situation. We're still getting beat up every day. If you have a restaurant out there that doesn't have a permit, are you going to allow them to continue to sell food to the public? And the food is even bad? Wouldn't you shut that restaurant right down? It's very simple, you know. Shut it down and get your permit. That's all we're asking. Shut it down and get a permit. About the complaints, I probably have 45 official complaints that I filed with the building commissioner. Last one was maybe a year ago. He said, don't even bother, Neil, because I'm not going to do anything with these. That's why we haven't filed any more complaints, okay? Now, mistakes were made. We admitted that tonight. Everybody knows mistakes were made. Well, let's fix the problem, okay? We don't care who did it. We don't care about the blame. Fix the problem, not the blame. Just shut these off for now. That's all we're asking. You know, it's just turn them off. Go for your permit. Diana Tilson also said she complained about the financials, about the town. It could be 3-6 months before you get into the special permit process. May, the Supreme Judicial Court came down with the order, you need a special permit. So what, you know, a year, we're going to get a permit in a year. In the meantime, those things are beating us up. Eliminate the nuisance. That's what the decision was from the ZBA on the nuisance. It's not mitigate the nuisance, it's eliminate the nuisance. So, just, you know, I'm just a human being, you know. I feel bad for my wife, because she's home all the time. You know, she goes in the back rooms when it's bad, we leave. 7 o'clock, okay, we're free again, let's open the windows, we can go out in the front yard. There's nowhere to live, so. Take the town out of it, just, you know, it's a nuisance. Please give the order to shut them off. Go for your permit, and then fine, you know, if you get a permit, turn them back on again. But in the meantime, don't put us through this. It's been 5 years, and it's inhumane. Thank you.
Thank you. I know the attorney said ask for a few minutes after everything to make a couple comments, so it doesn't look like anyone else. 5 minutes.
Well, thank you very much for listening. Again, I think I took more than my share of time. I know this is a difficult situation for everyone in town. We do think that if the board focuses on its job and the way it's treated this kind of situation before, that you should consider and talk with your counsel further about whether or not these fresh enforcement requests deserve a second look. We filed these requests after we received final word that a permit was needed. It does change things, as Member Foreman mentioned. We're in a different situation than even Judge Muse was in. Some of my clients experience much less distress under Judge Muse's order. The town has not put into their special permit application for Win 1 that they're willing to incorporate the 7 to 7 or the Sunday or any of those other provisions into their special permit. At this moment, the special permit application looks like it's asking for permission to go back and operate the turbines full time. I think Attorney Tillotson might have been suggesting that we focus on those conditions. In that process, I'm sure there will be a discussion, and I can state to you that about half of my clients have had a significant improvement in their lives since Judge Muse issued his order in November of 2013. The other half haven't. Linda Okagawa leaves her home regularly during daytime hours when it is a bad wind day. It's not a bad wind day every day, but I would say, and not every month is a bad wind month. The summer is not bad. I mean, that is a time when people want to be outdoors, but the summer is not bad wind-wise. These two turbines being stall regulated, the faster the wind blows, the harder the wind blows, the worse it is for my clients. So you've got the fall coming up, you've got the winter, and these are the bad months for these turbines. And I can tell you that Linda Okagawa, who's here tonight and didn't speak because we hadn't reached Wind 2, and she's only affected by Wind 2, or so she believes, she leaves her home regularly during bad winter months. And this is while it's operating only during the daytime. The Funfars and the Andersons are in distress, notwithstanding the 7 to 7 operation. The Drummies, the Elders, Mark Poole, Robbie Laird, much better under the Judge Muse order. So I don't want you to think that everyone is experiencing as much distress today as they were before. But about half of my clients report to me ongoing distress. So I think it's worth another look. I know you ruled not in our favor on our appeal of the June 11th, 2015 order. That was a different order. It wasn't a straight enforcement request. We were objecting to the zoning enforcement officer's self-initiated order after he knew about the appeals court decision. But we ask you to take a fresh look because there is distress that's ongoing, and we are in a very unique situation now. These are turbines that are really operating without a permit. So I know it's a very difficult position that you're in. I appreciate all the time you gave me. I appreciate that you allowed me to give you some of the background information. And I ask you to just dig deep here and consult with your attorney and just see, is this something we ought to consider issuing for both Win 1 and Win 2? And with Win 2, I know we've only sort of partially gotten there tonight. When we get there, we do have a different situation still because the town has not submitted an application for a special permit. Thank you again for your flexibility.
Did you, oh, you can take a few minutes.
First of all, just a housekeeping matter. The submission I made tonight was primarily in the Anderson case. I did ask in a footnote that it be incorporated into the other cases. I have a copy for each file if that would be.
Sure, yes, that would be great. I guess it goes in the file then. Okay. Yeah.
The only issue about harm that this board has to consider is whether our clients are aggrieved by the decision of the building commissioner. Otherwise, this board is a board set up under law. Where there's a remedy at law, it's not for this board to apply equitable principles. So it's not for this board to inquire at all whether there's harm to the town. The question is, under the law, the way it is, and the way this board has set up its rule of decision for cease and desist, whether it issues or doesn't issue. Now, similar to the Tavares case, you heard Attorney Tillotson acknowledge that it is technically operating illegally. That is precisely the same thing that Attorney Moynihan did in the Tavares case. And this board said, Attorney Moynihan admitted that the turbines were operating unlawfully. I mean, not the turbines, the contractor yard or the landscape yard was operating unlawfully. Therefore, the cease and desist is in order. So, Attorney Tillotson also said there were critical differences with the Tavares case. Well, the critical difference, I would say, to this board is that in the Tavares case, the building commissioner was enforcing against a citizen of the town. In this case, the building commissioner is not enforcing against the town, which he has repeatedly refused to do throughout the course of this. These are identical cases to Tavares. Tavares, again, had applied for a special permit or a modification of the special permit and had taken an appeal from that. He had a good faith belief that he was entitled to that special permit. But for the fact that Attorney Moynihan admitted that it was technically operating illegally, the course of this board's decisions have been, if there's a good faith belief that the use is lawful, then cease and desist is not appropriate. This is not that case. There's no special permit. There's been one applied for, but there's been no decision on that yet. Cease and desist is appropriate.
Attorney Tillotson, I will, if you'd like to say anything, a few minutes, that way everybody's on the same footing. You don't have to if you don't.
I don't think so. I made the distinction on the Tavares case. I think you understood the distinction, and that's all I would
Thank you.
look at. Thank you.
So how would you like to proceed? We're nearing the end of our scheduled hearing, which usually ends at 9:30.
May I make a suggestion?
Yes.
The case that was brought by Mr. Senni, entitled Appeal on Win 1, which is your file 69-15, is exclusively on Win 1. It's true that Mr. Watt filed a case in which he raises both Win 1 and Win 2. So I don't think it would be appropriate to close the Watt filing, if you will. But if there's no objection from the attorneys with regard to evidence submitted this evening on Win 1, then I would ask that the board consider closing the hearing on 69-15. And whether or not we deliberate after that is totally up to you. But I could at least offer some jury instructions if we're going to think about it for a while or talk about it now. So I wonder first if there would be an objection from anybody. It doesn't seem to be that way. But that matter is, we've done nothing but Win 1, and that matter is only about Win 1. So it would give us an opportunity to talk about this.
Okay. Do I have a motion?
Yes, I'm happy to make that motion. This is 68-15.
I have it as 69.
69.
Is that correct
Yeah.
with everybody?
Yep.
All attorneys agree at 69-15?
Okay. So move that we close the hearing on case 69.
So that was it then. So, Mr. Foreman and Mr. Van Kuren, all those in favor? Aye. And the
Only the
voting members
5
are just the
members.
5 regular members, I apologize.
So Win 2 has other issues that are not, it has the same issues to some extent, but it also has ancillary issues that you're going to have to answer, and we don't even need to bring those up tonight because it's 9:28. As to this matter, Win 1, I would urge the board to think about it in this way. Number one, you clearly have the authority to issue a cease and desist if that's what you choose to do. There's no doubt that you take on the powers of the building commissioner under Chapter 48, Section 14, and among his many powers is the power to issue a cease and desist. So the question is, should you? And in order to answer that, you have to weigh the evidence that was before you. Mr. Senni had a long PowerPoint, and it was very thorough in terms of laying out his case. On the town side, there's slimmer evidence with regard to the harm to the town in terms of balancing equities, but I would refer you, in Mr. Watt's filing dated July 29th, he did attach Judge Muse's preliminary injunction order, and from pages 3 to 5, the judge discusses the financial impact to the town. It's in the record. I don't think it's probably changed much, although this is a slightly older document now. But there's some financial information about the impact of the town, and I won't summarize it. I'll leave it to you to read it for yourselves. So ultimately, I do think that this is a case in which you have to look to the circumstances and decide whether to just issue no enforcement order, issue a total cease and desist, or do something in the middle. Now, I remind you that in the middle already is Judge Muse's temporary, or his preliminary injunction, and it does apply to Wind 2. So this, it applies to Wind 1 and Wind 2. So that's already the basis. This is the provision from Haddad that I think is really governing here. It says the true inquiry in each case is whether the building or structure is legally usable or modifiable and legally usable, and is intended to be used for a main or accessory use which is permitted by the applicable ordinance or bylaw. And it cites another case for that proposition. So there's clearly an opportunity here to apply for a special permit. Whether or not you would grant such special permit, I won't predict. But that's what the court has ordered the town to do, and that application has been made for Wind 1, not yet for Wind 2, but we'll take up Wind 2 on another night. So I do think that it's not an all-or-nothing proposition simply because it's unlawful or simply because it constitutes a nuisance by this board's prior decisions. Nuisance as a tort often inspires very different remedies, everything from shutting it down to paying permanent servitudes for damages. If all of us from law school remember Boomer from a New York case in which a cement plant with 325 workers is not ordered shut down, but instead ordered to pay damages. But that's for a judge to do in a later or a different forum. So I would urge you to think about it in that way. What is the proper thing to do given the harm that has been demonstrated by the appellants here this evening and the damage that would accrue to the town if you were to issue a complete shutdown order at this point in time. And you get the big money for this, so it's your deliberation at this point.
Well, can I have a motion to go beyond that, Perry, now that it's passed on there, Ken?
I move that we go, I think we better say till 10.
Okay. Can I have a second? Okay, so that was Mr. Foreman and Mr. Van Kuren. All those in favor? Aye.
I'm sorry, what time was that to go to?
10.
10. So, should we have some discussion?
Sure.
Okay. Paul?
You know, I've listened to both sides. You know, I think the town, rhetorically speaking, is in trouble here. I don't see a compelling argument from the town side. I see a very compelling argument from the side of the abutters who are aggrieved by this noise and the other effects. You know, I call balls and strikes, you know, on a daily basis, what I do, and I just, it bothers me that this has gone on so long, and that there's really been no resolution. A lot of new stuff has been introduced tonight that's very compelling, and it bears serious consideration. And you know, if I were to call it one way or the other, I think the compelling case is on the side of Mr. Senni and Mr. Watt. I can't see it any other way.
Ed?
I think there's opportunity for some relief in changing the operations of, I think that's doable. Low wind conditions, maybe that's part of it. Maybe there's times when it could run at night. I think those things should be looked into and looked into quickly.
TJ?
We dealt with a lot of information tonight, hearing from both sides about the lack of an order to cease and desist. And also with the town's application of the special permit coming up, and I'm just trying to weigh all that right now.
Need more time to review prior to?
Possibly.
Okay. John, discussion?
I understand both sides of this story and empathize with people that have to deal with an annoyance over a long period of time. I don't know if I'm quite at the point of moving in that direction, though, because the balancing of the harm done to both sides is I'm having a difficulty with that part of it.
Okay.
To me, it's pretty simple. I don't think, our mission as a zoning board is to, in part at least, to consider the impacts of various development actions on the abutting community. And we have a process for that. We issue a special permit where such mitigation might be requested. In this case, and I remember voting that, when it came before us before, that the special permit should have been issued. We did not have the supermajority required, but in the end, the court affirmed that we were correct, that there should have been a special permit. There's not a special permit. I don't believe we should sanction at what is at this time not a legal activity. I think we should, there's nothing that says that we won't eventually issue a special permit and that the town won't be able to resume operation under some set of conditions. But in the meantime, I believe that it's our obligation to say, you don't have a legal right to operate these things, shut them down for now.
Okay. I would lean toward actually the opposite end. I think that we made our decision in August on the basis of Haddad. I don't think that there are any changed circumstances since that decision, when we as a board decided that Win 1 shall operate until the special permit is either granted or denied, that the town be afforded that opportunity to apply for it. We relied on council's advice at that time. I don't think anything has changed as far as circumstances, perhaps more evidence or more information about some of the equities or, the special permit considerations might be before us tonight. But I think our focus tonight should be, what is the law as far as letting people who don't have, a special permit proceed. And I think that the law, in my opinion, is clear. The SJC, the appeals court, has said that people, when there is an available remedy, that those applicants, whether it's a town or any other landowner, be afforded an opportunity to receive that relief. So that's...
Well, again, the cases of the tear downs, those are irrevocable. So I understand you might want to delay on that, but this is not.
Yeah, just to add to that, I mean, these people have appealed as persons aggrieved by the decision of the building inspector. Evaluating all the information that was given tonight, the testimony from the abutters, are they aggrieved? I would say so. I would say so. I realize that we, in July, voted to uphold the decision of the building inspector, but at the time, all this information wasn't presented. So in light of this new stuff, I really do feel differently, because we hadn't really heard from the neighbors so much as we did tonight. So, I think that these people are aggrieved by the decision of the building inspector. That's just my thoughts on it.
The person aggrieved standard is in Chapter 48, Section 17, and it's standing. I don't think, correct me if I'm wrong, I don't think any of you would disagree with the proposition that they have standing and that their person's aggrieved for that purpose. But so I don't want to use that term loosely. It really goes to whether or not they're eligible to participate in this appeal and subsequently in a court case. And there's no doubt in my mind that they have standing. So what I'm hearing is two votes, Mr. Foreman and Mr. Murphy, to reverse the building inspector's decision, one vote that wants to, two votes to go along with Mr. Senni, one vote to go along with Ms. Tillotson. And it only takes two votes here to eliminate the possibility of a reversal. The reversal of the building inspector's decision must carry by a 4-to-1 vote.
Question for Attorney Bobrowski. So how important in the assessment of applying a cease and desist order at this time is it to be considering what your the ultimate decision might be with respect to the special permit?
You haven't heard the evidence yet. That would be premature on your part.
So there's no requirement, for example, that we say, well, the special permit, there's no chance it would be, approved,
No.
or, well, there's, surely they're going to get a remedy through the special permit. That's irrelevant.
You must
to
make
this
your decision on the special permit on the record of that hearing and
So
nothing
all
else.
we're talking about right now
Is this.
is what might be a temporary cease and desist order until such time as that's resolved. And again, I come down to, for more than 5 years, these folks have been at least made a strong case that they're suffering under the operation of these wind turbines. We now have affirmation of the court that they don't have a permit to be there. And to me, the combination of those two things is sufficient for me to say, okay, let's shut them down until we can resolve the issue of the special permit.
Okay, just so we'll engage. But the town, when it received a building permit, so whether or not it needed a special permit, obviously now we know in hindsight it did need a special permit. But why shouldn't the board or the town be afforded an opportunity to apply for that special permit since it expended?
It will. Our decision now doesn't
Right.
preclude them from applying for a special permit, and I'm sure they are going to.
Well, they have.
Yes.
Yeah.
So we will have adequate opportunity to consider that at that time. And if we can agree on a way to operate that's reasonable under the regulations of the old version, apparently, of 166, 4166, then I would assume that they would go back into operation. But in the meantime, we're looking at a couple of months when they're not operating versus continued, at least alleged health impacts. So I just think the damage to the town of a couple of months of not having these things spinning can't be that severe.
We're talking Win 1,
Win one.
not these.
That thing.
So how would you all like to proceed? TJ, can you make a decision tonight? Do you need to review additional information?
No, well, so
I mean,
you're basically saying the principles of had it don't apply. You
I
made
think,
the distinction that it was a tear down.
I think that it's different. Let's say you had, if we had a business operating illegally, I think we'd ask them to stop if they, until they got a special permit. I think that's legitimate. And this is not a case where it's been happening for just a couple of months, or it's just come to our attention. This has been going on for years. When was our, when was the vote for the, where we, I think it was 3-1?
Yes.
On
I
the
was
special
much younger
permit.
then. When was that? 12?
It was a lot of years ago.
It was,
There was a different composition of the board, I
Right.
know that.
was it 12?
I think it was 2011.
11 or 12 were.
Yeah. So,
Well, one opportunity would be if you stop it now, let them stop the operation. Maybe it'll hurry the town up come up with a solution to some other part-time operation. Might hurry them up. Get bigger incentive.
possibly.
Well, it's also based on this board, with the special permit with the time frame. So
Yeah,
there's a little bit more involved than just
Yeah.
hurrying up the
Yeah,
town.
we've certainly
this
heard
board.
testimony that the town has not been very responsive from some of the abutters, whether that's,
I think also Ernie Tillotson said there was a lot more data there that needs to be, it's already there, it wasn't highlighted in the presentation, whatever some slides.
but, we're not voting to shut them down forever
Right.
tonight, so I think that's,
If you overturn the building commissioner's determination, I don't believe you can give a time limit on your cease and desist.
no, but
Oh, the matter.
presumably if we're going to hear a case on a special permit, right?
Right, I
At
just,
that time,
I just don't want it based on the fact that you only think you're doing it for 2 or 3 months.
well,
You don't know how long it's going to be. Correct?
Well, if you were to issue a cease and desist, they could cure it by getting a special permit, and it would lift at that point, but you don't, that's essentially what you're saying, is until such time as you get a special permit.
That's better.
Or otherwise make it lawful. I
that's
suppose
what
you
I'd
could-
like to say.
I suppose you could make it lawful with a variance too, but nobody's talking about making that application.
Okay.
yeah, a lot of information was presented tonight that really helped me understand it a little more and just changed my mind on the matter from July. But yeah, it would bother me to allow this to continue to run as an illegal structure. I mean, I deal with this stuff in my professional life, issuing cease and desist orders for gravel operations or whatever it is, anything that comes down the line. And generally, when something's unlawful, generally, it's a registered letter. That's it.
I mean, we complain from time to time that enforcement is an issue. No special permits should be enforced.
TJ, you seem to be the unknown here. I think everyone else has said.
If he needs more time,
Yeah, we can, yeah.
we're well within our 100 days, so.
Well, I was just trying to flush out everyone's opinion. To me, it's a close call. I mean, the abutters have been aggrieved for over 5 years now. The multiple lawsuits and this proceeding, the special permit proceeding. I'd have to be with the abutters on this, I guess, is what it really comes down to.
Okay. So if anybody would like to make a motion, if everybody feels like they're ready.
Are we ready?
Sure.
So let's see, what are we moving here? We're moving to 69:15. To request a cease and desist order overturning the building commissioner, is that correct?
You will return the building commissioner and approve the appeal.
And approve the appeal.
And that's just for 69:15.
Correct.
So moved.
So that is Mr. Foreman. Is there a second?
Second.
And Mr. Van Kuren. All those in favor?
Aye.
And I'm opposed. So that is 4-1. Motion carries.
Okay.
Okay. So the second, I guess, when we deal with Win 2, we need to discuss dates for that.
So we have to.
Yeah,
what do
but
we
we're
do?
going to need
These are on the docket for tonight. Do we need to vote to?
Continue them?
Continue them, yes. So you'll be
Excuse me, we're
continuing,
still having public hearing.
you'd be continuing Mr. Watt's appeal because it contains reference to Win 2. And I would assume that we would take up his Win 1 decision at another time. But I can't see why you'd do anything differently. And
68 and 70.
the other one is exclusively, Mr. Senni's other appeal is exclusively on Win 2.
Okay. So can I have a motion to continue, I guess?
Let's talk about a date,
Okay.
because we don't have a
Thank you.
date agreed upon by all parties yet. What is the dates on that front of the file for the?
Can't do the 15th?
The 100 days is
October 15th?
November 4th.
I'm sorry?
The 100 days?
Uh-huh.
November 4th.
Yeah, right around there.
For both of them? Because
That was, that was 68, 70 is November 6th.
Yeah.
And that one we just decided on.
So
Well,
do you want to do them on October 29th?
yeah, I do want to do them on October 29th, because well, at least we'll be within the,
The 100 days?
yeah. I mean, I think,
All attorneys are going to be here that night, so we're still discussing it.
when we look at Win 2, I should alert the board that there are some other issues that we will have to hear evidence on. Although the impacts of Win 2 were covered in the slide or the PowerPoint presentation. There are two ancillary issues that you'll have to decide. One is whether or not notice was received of the issuance of the building permit for Win 2 at the time that it was issued, and I believe it was issued in 2010. There have been a line of cases from 2008 that say if you either got notice or had a duty of inquiry to ask and didn't, you're held chargeable with the 30-day appeal period for the building permit issuance. I don't know anything about the extenuating facts or circumstances of that back in 2010. You're going to have to decide that. Because if they had to apply within 30 days and they didn't, then it's gone. And then the second aspect of that is if it's gone, if they didn't have a duty to apply for the building permit within 30 days, they have a 6-year statute of limitations to seek zoning enforcement. However, we're in year 5, and there have been cases, I believe Richardson has been supplied to you, in which the court has found latches, that there was a duty to make an earlier petition for enforcement and not let 5 years of reliance and expense go on the part of the town. So I don't have any opinion about any of that because I haven't heard any facts yet. You will have to hear some evidence about that. But I alert you, that's the nature of the evidentiary hearing for the remaining pieces of these two appeals on that night, plus you have the special permit.
So, Mark just suggested possibly putting it on October 29th along with the special permit application following,
I think, I'd be up for that, personally.
because then we're within the 100 days
And I know I can
on both.
be there for that one.
Don't put anything else on.
Yeah.
That's for
What
sure.
what time does that hearing start, Sri, right there?
At 6:30. I mean, the board can vote right now to do the continuations at an earlier time and then take them,
Out of
vote to take
order.
them out of order. Because this is going to be a long evening if you don't start just a tad earlier. I mean, it's still going to be a long evening.
I know that some council comes from Boston too, and
Mhm.
north, so how
6?
early?
Can we do 6?
Fine with me.
I was going to suggest a little earlier,
Yeah,
but yeah.
5:30.
It might be hard for me to get there earlier than 6.
5:30, okay?
It's actually easier to leave earlier for the track.
Yeah,
5:30,
right.
okay with all the attorneys and the board members?
I'm not sure I can get there at 5:30.
No problem here.
6.
All right, 6 then. Ken can't get here, we need him.
That's your
Well, I
next
guess
meeting.
we don't really.
Do you still
need
feel
Ken.
that way?
I guess we don't really need him, we should get John. John was here.
Okay, good.
I will have the 4-to-1
6.
decision down here for your next meeting. Seems like you're meeting every day, but I'll have it here for next Thursday. So,
So I'll put that on the open meeting, which I posted that agenda today, so I'll revise it. So 6 o'clock, October 29th, is everybody agreeable to that?
Not 5:30?
No, Ken Foreman said he
Okay,
can't make
6.
it. You can blame him.
Okay.
He has to bring
Apparently
coffee.
got it at 6:30 tonight.
So then can I have a motion to continue, I guess 6815 and 7015?
I make a
To
motion.
10:29 at 6 o'clock.
Right, I did.
Okay.
Okay.
So that's,
Is that
is there a
Yeah.
second?
Second.
Okay, so that's Mr. Van Kuren and Mr. Hurry. All those in favor?
Aye.
Aye. So those are
5:30.
continued.
Okay, we've got an open meeting.
Yes.
stuff to do.
So we have some business items to handle, so if you could exit quietly, it would be appreciated.
Hand over to the sheet.
Thank you.
Well, at least they'll still get through, which is out.
All right.
Yeah.
No, the ones in front of you.
Oh, sure.
There you go.
I got all my hands scratching on there. Are they official records?
Yes, they are.
Oh, great.
Let's do minutes.
Excuse me, if you could exit quietly. Thank you. September 10th, 2015 minutes.
Yes, I read them, okay.
Yeah.
So I wasn't here.
It would just be the four. John,
Was I here?
TJ, Ed, and Paul are the ones who vote on the minutes.
Did everybody have a chance to review?
Yeah.
Okay.
Yeah.
Somebody like to make a motion?
Make a motion to
Is there a second?
Everybody?
second.
Good night, thank you for
Good
your
night,
help.
thanks.
I don't know who made the feedback.
I second, yeah.
So all those in favor?
Aye.
All four members are in favor?
So that
Yep.
was unanimous.
4-0. Okay, moving on. I have an administrative request by the board, for the board, by Elizabeth Ledwell.
Oh, yeah.
If you remember her, she was putting the sunroom on, and there was a discussion about the door. Because she wanted to keep a door, she didn't think she could open it up.
Door into the kitchen.
Yes, because she didn't think she could open it up, the board conditioned a deed restriction. She has since met with an architect, and they've discovered a way to remove the existing 4-foot door. So they want to remove the door and have a 4-foot wide clear width opening. So they're going to remove this door, and this little portion over here will also be a half wall
Hmm.
to get more quite into the room.
All right.
That
So
looks
if the
nice.
board.
Well, that was
will
what we
then-
originally wanted, so.
Right, and she didn't think it could be done. And she didn't want to go through the expense, quite frankly, but they don't want, her father is a real estate attorney, and didn't want a restrictive covenant on her property. So they did come up with a way to do it, and she's okay with it. So if the board is amenable to this, you will make a vote to lift the restrictive covenant and to approve this plan.
Make a motion to lift it.
Okay,
Second.
all right. So that
And-
was,
To approve this plan.
and to
Yeah.
approve plan. So that was Ed and
Dated
Paul.
September 14th,
Yeah.
2000.
No, dated September 5th.
Oh.
Received September 4th.
Yeah, revised 9/5.
There you go.
Okay, all those in favor?
All right.
Aye. Unanimous.
Thank you very much. That's all that I have.
The next, the next one is the bylaw review update. I have
And
a
it
couple.
hasn't changed. Remember, Brian Curry had said, well, you wanted it kept on the agenda, and Brian Curry said they're not going to get to it until after the town meeting, I believe,
Till you
sometime in the
retire.
fall or after town meeting.
I have a note on the bylaw change, and I don't know if this is already on there, but the nuisance provision that's in our zoning bylaw,
It is not. So can you add that to the,
What about it?
under the bylaw revision?
I don't think that that should be a zoning board determination. I don't think it usually is a zoning board determination.
Well, it's in the bylaws as that, so if anybody wants to appeal the decision of the building commissioner on what they believe to be a nuisance, you've got to go through the whole standing and everything else. But
I
it's
don't
always,
think nuisance.
so you want that
Well,
reviewed?
that would be my, that
Who
would
would
be.
you suggest? Because it is the building commissioner, and then we get the appeal.
I would have to, let me look how it's done in other
Okay.
towns, because I don't think it's usually a zoning. Paul, do you know if it's,
What are we actually referring to, Kim?
like, there's a,
24110
there's a provision in our bylaw that lets you,
says, "No use shall be permitted which would be offensive because of injurious or obnoxious noise, vibration, smoke, gas, fumes, odors, dust, or other objectionable features."
We see
Or
that
be-
a lot.
Hmm?
That's in a lot of the bylaws.
It is?
Every town I've worked in, yeah. Like a
because I've never come across it in any other town.
Well, it's usually tied to like a home occupation. The
Right,
home-
and then we have
Well, this
specific
is-
standards.
Right.
This is a
This is-
standalone,
Remind me of that.
standalone nuisance provision.
No, I've never seen it.
Because we've
Email me
had,
tomorrow.
appeals
Correct.
saying, like, for example, the wind turbines are a nuisance. So then
Right.
we're considering whether or not it's
What's a nuisance? That's so subjective.
And it's, yeah, and I think there's a legal private standard,
Right.
and then we have this, so.
Yeah, no,
I
I've
would
never
just-
seen that. As you
Okay.
say, it's always connected to something like,
Performance
Right.
standards, but not standalone.
Okay, so maybe it could be, it should be moved. Something
Or
needs to
if
be
that's-
in there, but it
yeah.
might need to be moved to specific.
And I think it is.
Yeah, there's probably stuff in the home, I certainly know in the home occupation, there's plenty.
right.
Plenty of,
Can't generate dust, noise,
Right.
you know,
can't make coffee. that
exactly.
smells.
So I guess that's all. Any correspondence, board updates, future agenda items?
Just October 17th, the board workshop. I'm sorry, I
Yes.
haven't got that
Ken, are
sheet
you
out
able
to
attend?
17?
find out who's bringing what food.
That's a morning thing, right?
It's a Saturday
9 to
morning.
noon.
Yeah, I think so. but-
Okay.
Ken's bringing the French bakery.
Oh, yeah. Oh, yeah. Okay. Sounds good. All right, so,
No,
good night.
good night. That's a new way of adjourning.